I know. Except your head's cut off. Your dad is coming.
Which one?
Good afternoon, Mr. Campbell. Can you see and hear me okay?
Yes, sir.
Excellent. All right, Mr. Campbell, can you also see Mr. Schmidt on your screen? He's your attorney here in Vincent County.
Yes, sir.
Okay. All right, Mr. Campbell, I'm going to call your case. This is cause number CR 25-32, State of Texas versus Zachary Dale Campbell. We're set for arraignment. Mr. Campbell is appearing via Zoom today from the Ellis County Justice Center. Mr. Schmidt, are you ready for arraignment?
Judge, we are ready for arraignment. I do know that I have not spoken to Mr. Campbell since his indictment. I've reviewed it and I've met with him previously. I know that his name's spelled correctly. He understands the charges. If you would, Judge, post that indictment real quick so I can finish up.
Okay. Mr. Hartwell, are you in your LGS at this time?
Yes, Your Honor.
Would you mind? I'm going to authorize you to be able to do that. I don't have mine logged in just yet, and so it would take just a moment. If you wouldn't mind assisting us, I think it should be the only one.
Yes.
Can you see that okay, Mr. Schmidt?
I can.
Mr. Campbell, can you see that as well?
Yes, sir.
And Judge, we would waive formal reading of that indictment. Mr. Campbell's name appears to be spelled correctly. It is a third-degree felony, range of punishment of 2 to 10 in the pen. We'd enter a plea of not guilty at this time and ask that it be set for a pretrial hearing.
All right, thank you, Mr. Hartwell. All right, then the court finding that Mr. Campbell has waived the formal requirements of arraignment, the court entered his plea of guilty enters his plea of not guilty into the record, and the court sets Mr. Campbell then for a pretrial hearing. Mr. Schmidt, do you know how long Mr. Campbell may be in the Ellis County custody?
No, sir, I didn't know he was in Ellis County custody until today.
Mr. Campbell, I don't want you to say anything to incriminate yourself, but do you have a charge? Are you pending a charge there in Ellis County?
Yes, sir.
Do you know when your next court date is there in Ellis County?
No, sir.
You don't. Do you have an attorney there in Ellis County?
Yes, sir.
And what is your attorney's name?
I haven't met her yet.
Okay. All right. So let's do this.
But I also just came from another county, Kaufman County, and I got 3 years deferred probation over there.
Okay. All right, Mr. Schmidt will look into that, I'm sure. All right, I'm going to reset you to May 27th. If you're still in custody in Ellis County, we may have to appear via Zoom again. If not, we may have you bench warranted over so you can meet with Mr. Schmidt, go over your case, and then make an announcement. So it'll be May 27th for pretrial, Mr. Schmidt, and we'll kind of figure out where Mr. Campbell is as we get closer to that date. All right, Mr. Campbell, any questions?
Oh, sir.
All right.
So you're saying if I get released from here, I can't go home. I have a hold, then I have to go to court.
I'm not sure. Is he on a personal bond here?
He was, Judge. Yes.
Yeah, so I show that you're on a personal bond here. So that means if you're released there, then yeah, you'll be able to go home and you won't be held over.
So just come to court.
Well, you're going to have to come back on this case, May 27th. Yes. But I'm saying I don't believe that the Vincent County Sheriff's Office is going to come pick you up and keep you detained. At this point, you're still on a personal bond, it looks like.
All right.
That's correct. And you're not getting any credit while you are in jail on this case in Vincent County.
Sir?
I said you will not be getting any credit time for the time you're in custody if you remain on bond on our Vincent County charges here, just so you're aware of that.
I don't know what that means.
Fair enough. Give my office a call. I'll explain it to you.
All right.
All right. And do you have anybody there at the Ellis County jail staff with you?
Yes.
Okay. Hey, I just want to say I appreciate you getting Mr. Campbell on today and letting him appear via Zoom so that we can move forward with this case.
Hey, hey, Mr. Richard Smith, I can get your phone number?
No, just have somebody at the jail look it up. We'll talk to you later.
So be in touch, look up his number online, and then otherwise I can have my coordinator email you his contact number over to that to the Ellis County Jail, okay?
All right.
All right, have a good day, sir. All right, Mr. Schmidt, who would you like next?
Josh Ibara.
All right, Joshua Andrew Ibara. This is cause number CR 22-161 and CR 25-88. Mr. Ibara is set for arraignment today on failure to comply with sex offender duty to register and pretrial on the other sex offender failure to register. Do you need the indictment on that CR 25-88?
No, sir, I don't. We'd waive formal reading of that indictment and enter a plea of not guilty on that as well. We're gonna ask that the other case that's on pretrial be reset for an additional pretrial and have those two carried together.
All right, court finds that Mr. Ibara in cause number CR 25-88 has waived the formal requirements of arraignment. Court enters his plea of not guilty into the record. Court sets each matter for pretrial hearing on May 27th at 1:30. Should Mr. Ibara make bail, then his hearings will be on the same date at 9 a.m.
Matthew Hog.
Matthew Haro,
Hog.
Hogg. All right, this is cause number CR 25-43, State of Texas versus Matthew Tom Hogg for arraignment. Go ahead.
Judge, Mr. Hogg's name spelled correctly, understands the charges. We waive reading and enter a plea of not guilty.
All right.
Last pretrial.
All right, court will set Mr. Hogg for pretrial hearing on May 27th at 1:30. Court enters his plea of not guilty into the record, finds that he has entered a plea of not guilty.
Mason Hogue.
Mr. Hogue, if you'll come forward, this is cause number CR 24-233 and CR 24-234. Mr. Hogue is set for docket call in each case.
That's correct, Judge. I would let the court know that Mr. Hogue had an FC 24 case filed in the county court of law. I filed a motion to transfer that. I suspect, I think I filed it yesterday. So just so you're aware, it was running in CCL. I think Judge Winters granted that yesterday, but
Do you know that cause number FC 2024?
you know, I don't know it right off the top of my head. I don't have it in my notes.
Okay, well, when that is, when it makes its way to me, then I will grant that and we will bring that case up and we'll run them all together.
Yes,
And Your Honor, I can provide that for you. It's FC 24-146.
Thank you, Mr. Harwell. Okay. All right, and so are you asking for all those to be set at for a docket call together?
yes, sir, please.
All right, court will set all three of those cases for Mr. Hogue on May 27th at 1:30. Oops.
Michael Rodenb.
All right, this is cause number CR 25-55. State of Texas versus Michael Lance Rodenb. We're set for arraignment. Go ahead.
Correct, Judge. We received the indictment, waived the reading, and spoke correctly, enter plea of not guilty, asked for pretrial.
All right, court sets Mr. Rodenb for pretrial hearing May 27th. Finds that he has waived the formal requirements of arraignment. The court does enter his plea of not guilty into the record.
Melissa Shunover.
All right, this is cause number CR 22-46, State of Texas versus Melissa Shunover for docket call.
Judge, we'd ask to set her for a plea.
All right, how much time do you need, Mr. Schmidt? I've got some hearings coming up next week. I got the 15th, or we could maybe do it on April 29th.
I guess April 15th is fine.
15th? All right,
Yes.
court sets Ms. Shunover then for plea before the court, April 15th at 1:30. Who would you like next?
Michael Williams.
Michael Scott Williams, cause number CR 24-193. He's set for docket call.
That's correct, Judge. We're gonna ask for an additional docket call. I did provide the state with some information that they're following up on. Like a little bit more time to allow them to do that.
How much time do you need, Mr. Schmidt?
Just standard reset, Judge.
You think like 2 weeks, or do you the end of May?
I think the end of May would be probably a conservative answer.
How much time, Mr. Hartwell, do you think?
May 27th should give us enough time, Your Honor.
All right, court sets Mr. Williams for a final docket call, May 27th. I'll expect Mr. Williams to tell me if he's taking a plea or requesting a trial.
Yes, sir.
Who'd you like next?
Jimmy Collier.
All right, this is cause number CR 25-36, State versus Jimmy Dean Collier for arraignment.
Judge, his name is spelled correctly, understands the charges. We waive reading and enter plea not guilty.
All right, court enters Mr. Collier's plea of not guilty into the record, finds that he has waived the formal requirements of arraignment. Court sets this matter for pretrial hearing May 27th at 1:30. Who would you like next?
You should have a handful of pleas in your queue.
I believe I do. Yes, I have Mr. Hegel.
He'll be last, Judge.
Okay. Also have
You got Mr. Pinrod.
got Mr. Pinrod, and then maybe a Mr. Delgado or something. It doesn't.
Mendez, Eden Mendez.
That's who it is. Yeah, it doesn't say on email.
I'm ready on Mr. Pinrod and Mr. Eden Mendez, so either one of those.
All right, Mr. Mendez, come on forward. And Ms. Abraham, I don't see Collin County in the waiting room. I do see the attorney for the Collin County inmate, but not Collin County, just so you're aware. All right, Mr. Mendez, this is cause number CR 24-239. Sir, will you raise your right hand? I'm going to place you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah, you have to answer to him. Yes, he's asking if you're gonna tell the truth. Yes.
You understand I'm placing you under oath and you're being sworn to tell the truth in court today?
Yes.
Okay, you can lower your hand. All right, your name is Eden Joel Delgado Mendez, is that correct?
Yes.
And Mr. Mendez, are you a United States citizen who reads, writes, and speaks English?
No.
You're not a citizen?
No.
Okay. Do you understand that any plea to the court today could have an effect on your legal status within this country?
Yes.
Have you talked about that with your attorney, Mr. Schmidt? And you understand that potential immigration issues?
Yes.
All right. You do read and write and speak English, though, correct?
Yes.
Okay. In this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney and the work that he's done?
Yes.
Do you have any questions about your plea agreement and any of the paperwork that you've read and signed?
No, I'm good.
All right, then, Mr. Schmidt, do you believe Mr. Delgado to be competent today? And if so, have you explained to him his rights regarding this case, also the potential consequences with his legal status in the country?
Judge, yes, I have explained to him his rights. In addition to that, Mr. Mendez has a immigration detainer. And although I'm not an immigration lawyer, he understands the consequences.
Okay. All right, Mr. Delgado, you are charged by indictment with a second-degree felony offense of aggravated assault with a deadly weapon. However, today I see that the DA's office is making a recommendation that you be allowed to plead guilty to a lesser included offense of a Class A misdemeanor terroristic threat of a family or household member. They're recommending that upon your conviction that the court assess punishment at 244 days in the county jail, with which you would receive credit of 244 days of time already served. In addition, you would be fined $500. You would be responsible for court costs of $270 and reimbursement fees of $520. Is that your understanding, Mr. Mendez, of the plea?
Yes.
All right, understanding, and well, let me tell you, the range of punishment for a Class A misdemeanor is confinement in the county jail for up to 365 days and a fine up to $4,000. Do you understand those as well?
Yes.
All right, Mr. Let me ask, so on the judgment, it says, Eden Joel Mendez Delgado, but on my docket, it says Eden Joel Delgado Mendez.
Yes, it's the same. I got as a last name and middle name. I got two last name.
Is it Mendez Delgado or Delgado Mendez?
No, Mendez Delgado.
Mendez Delgado. All right, so the paperwork appears to be correct. Excellent. All right, so Mr. Mendez Delgado, then how do you plead to terroristic threat of a family or household member? You plead guilty or not guilty?
Guilty.
And are you pleading guilty to that crime because you are guilty of committing terroristic threat?
Yes.
Okay. And has anybody threatened you, forced you, or pressured you to plead guilty to that crime?
He's asking if anybody's forced you to plead guilty or if you're doing it on your own.
No.
You're pleading guilty because this is your independent decision?
Yes.
All right. And nobody's threatened you, nobody's forced you, no one's made you, no one said, hey, listen, Mr. Mendez Delgado, you have to do this.
No.
Okay. All right, then the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that the state is in compliance. Victim impact statement was sent out in October, was not returned as part of this plea. Attempted follow-up and we were unsuccessful with following up with the victim.
Thank you, Mr. Arwell. All right, anything further from the defense?
No, sir.
All right, court is going to review the evidence. All right, the court finds that there is enough evidence to convict the defendant of this offense. The court will follow the plea agreement and recommendation of the DA's office. The court hereby convicts Eden Joel Mendez Delgado of Class A misdemeanor terroristic threat of a family or household member, assesses punishment pursuant to the plea agreement at 244 days confinement in the Van Zandt County Jail. Court will give the defendant credit for those 244 days of time already served. The court orders Mr. Mendez Delgado to pay $500 fines, $270 court costs, and $525 in reimbursement fees. Mr. Delgado, once you are released from custody, you need to report to the courthouse to make payment arrangements to pay off your fines and fees. Your failure to do so will result in the court issuing a warrant. Do you understand that?
Yes.
All right. I'm gonna have you step over to be fingerprinted with the deputy.
Yes, ma'am. Thank you, ma'am.
All right, this is cause number CR 24-281, State of Texas versus Lucas Wayne Pinrod. Mr. Pinrod, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. Mr. Pinrod, are you a United States citizen who reads, writes, and speaks English?
Yes,
Have you ever been diagnosed with a mental condition?
no,
In this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done as your attorney?
yes,
Do you have any questions about the paperwork that you've read and signed today?
no,
Mr. Schmidt, do you believe Mr. Pinrod to be competent? And if so, have you explained to him his rights regarding the case, including the advantages and disadvantages of a deferred adjudication plea?
Yes, to all those questions.
All right, Mr. Pinrod, you are charged by indictment with a third-degree felony offense of cruelty to non-livestock animals that does carry a range of punishment of not less than 2 years in prison up to a maximum of 10 years in prison and a possible fine not to exceed $10,000. The plea agreement being offered by the state is upon your plea of guilty. The court is to defer a finding of guilt and place you on 4 years of community supervision with a $1,500 fine, and you're ordered to not have any animals in your possession or care during your probationary term. In addition, you would be responsible for court costs and reimbursement fees. Is that your understanding of the plea agreement, Mr. Pinrod?
yes,
All right, then how do you plead to cruelty to non-livestock animals?
guilty,
Are you pleading guilty to that crime because you are guilty of committing that crime?
yes,
Has anybody threatened, forced, or pressured you to plead guilty?
no,
Court accepts the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
That is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds that there is enough evidence to convict the defendant of this offense. The court will follow the plea agreement and recommendation of the DA's office. The court hereby defers a finding of guilt for Lucas Wayne Pinrod on cruelty to non-livestock animal. The court places Mr. Pinrod on 4 years community supervision, orders him to pay a $1,500 fine, $290 court costs, $520 in reimbursement fees. Further, the court orders that Mr. Pinrod not have any animals in his possession or care during his probationary term. Furthermore, the court orders that Mr. Pinrod be in the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. After that, the probation officers will give you more information.
Well, you just have to plea.
You make everything again.
Thank you.
Are you ready? I need anyone else?
Yes, sir. I'm ready on Christopher Crutcher.
All right, this is cause number CR 24-302, State of Texas versus Christopher Edward Crutcher. Is Mr. Crutcher doing a plea today?
Judge, we have had a plea agreement on the case that's indicted before the court right now. I believe Mr. Crutcher has picked up an additional charge, or we have some other issues that are throwing a monkey wrench into our plea that I'm gonna have to regroup with the DA's office. So we'd ask to set him for a docket call on this currently indicted case.
All right, court will reset Mr. Crutcher for docket call May 27th at 1:30. If this new case gets filed, then once it's indicted, then we'll get them going on the same track.
Not wrong, Your Honor.
Mr. Schmidt, is Mr. Crutcher still on bond with Roy Brockway?
I would assume not, but I haven't checked his holds because this is a new development, Judge. I'll check.
Okay, it's just showing up on my docket, so I wanted to make sure.
Roy Mitchell.
All right, this is Roy Mitchell III, cause number CR 25-23 for pretrial.
That's correct, Judge. I've met with the met with the DA's office. We've got Mr. Manning and I have co-defendants in this particular offense. We have some evidentiary issues that are outstanding that I think what we'd like to do is ask for an additional pretrial on Mr. Mitchell. Give the four attorneys involved in these cases an opportunity to sit down together and see if we can't figure it out. So from that perspective, we'll request an additional pretrial setting. In addition to that, Judge, based on those discussions, I'd make an oral motion for a bond reduction. We're requesting a PR bond on Mr. Mitchell. The state is in agreement with that. I think I have a signed order in my email from Mr. Hartwell, and we'd ask the court to entertain that and grant that as well.
Hartwell.
Your Honor, that's correct. I signed that and got it back to Mr. Schmidt here not too long ago.
And what did you say the agreement was on that, Mr. Schmidt?
The agreement is for, I think it's bond is set at $50,000. We'd agreed to a $50,000 personal recognizance bond, or PR bond, or personal bond.
Okay. All right, court will review that. All right, do you want me to set this for May 27th?
Yes, sir.
All right, court sets Mr. Mitchell for additional pretrial May 27th at 1:30.
And Judge, as far as, obviously I've made an oral motion for PR bond. Would the court like for me to email the proposed order to your coordinator? Something like that.
Yes, please.
I'll get that done here in a minute. You're good to go.
Miss Tabraham, do you need to bring in Mr. Munoz from Collin County?
Yes, Your Honor, please.
It says arraignment / plea.
Yes, and the plea papers should be on your bench.
All right, let me bring in the attorney and Mr. Munoz. If you'll go ahead and turn yours off, mute, turn your camera off.
Good morning, Judge.
Good morning. Good morning. Do you say your last name Alanami?
Yes, good enough.
Alanami? Okay. All right. Good afternoon, Mr. Alanami. All right. This is cause number CR 16-602, State of Texas versus Jose Luis Munoz. Mr. Munoz, can you see and hear me okay?
Yes, perfectly.
All right, good. And can you see your attorney as well?
No, I cannot.
All right, you may have to have jail staff change your view to gallery view up in the top right. There's a view button.
All right, let me call it real quick.
Yeah, let's do that.
Excuse me. I need to change the view so I can see my board. You said it's in the top right.
Should be a breakout room.
No, just change the view to gallery. That way he can see the prosecutor and he can also see the defense attorney.
Perfect.
Do you see him now?
Yes, I see him perfectly.
All right, and then the prosecutor is Mr. Hartwell. He's also in our court hearing today. Okay, good. All right, Mr. Munoz, sir, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right, you can lower your hand. All right, is your name Jose Luis Munoz?
That's correct.
And Mr. Munoz, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No, I have not.
In this case, you are represented by your attorney. Is it Hadi Alanami?
Yes.
Yes, Your Honor.
All right. And are you pleased with Mr. Alanami as your attorney?
Yes, I am. Very pleased.
Do you have any questions about the paperwork that you've read over and signed that is your plea agreement?
No, I completely understand them.
Okay. All right, Mr. Alanami, do you believe that your client is competent to enter into this plea agreement today? And if so, have you explained to him the advantages and disadvantages of a deferred adjudication plea?
Yes, Your Honor, to both questions.
Okay. Mr. Munoz, in cause number CR 16-602, you are charged by indictment with a second-degree felony offense of possession of a controlled substance in penalty group 3, greater than 200 grams, less than 400 grams. That does carry a range of punishment should you be convicted and sentenced of that offense of not less than 2 years in prison up to a maximum of 20 years in prison and a possible fine not to exceed $10,000. I see that the plea agreement and recommendation of the DA's office is upon your plea of guilt to that offense. They're recommending to the court that the court consider the evidence, not convict you today, but rather place you on 2 years community supervision with restitution in the amount of $180 plus plus court costs in the amount of $290. Mr. Hartwell, I do see that there's reimbursement fees of $585. Do you know if that's it looks like perhaps there was a court-appointed attorney prior to Mr. Alanami. Is that correct?
Yes, Your Honor. It appears, so I do see an order appointing Mr. Schmidt from December 27th of last year.
Okay.
So I'm not sure where the timelines are, but I do see that order.
Okay. And so, Mr. Alanami, you filed a motion to substitute as counsel. Is that correct?
I didn't file a motion to sub. I filed a letter of rep. I was not aware there was a court-appointed attorney at all.
Okay. All right. Well, give me just a moment and let me look into that real quick. Stand by for just a second. It appears that Mr. Richard Schmidt was appointed as counsel for Mr. Munoz back in December of 2024. So I'm going to display that here. So it appears we probably should have done a motion to sub, but I think whenever your letter of rep came in, we just switched it over. So Mr. Schmidt was on the case until you followed your letter of rep, Mr. Alanemi, which I think was in March. Is that correct? March of this year. So that's where the cost is coming.
Sometime around there.
Okay, so that's where the cost is coming from. The reimbursement fees of $585. So Mr. Munoz, in addition, you would have court costs of $290, reimbursement fees of $585. 500 of that is for your previous court appointed attorney that was requested and granted, and then $180 for the testing of the substance in this. Looks like the state is agreeing to dismiss cause number CR 16603, which is a possession of marijuana, 4 ounces to 5 pounds. So that constitutes the agreement that I see before the court. Is that your understanding of what you're asking the court to approve, Mr. Munoz? Mr. Munoz, are you still there? Have I
I
lost?
think he froze. I think he froze.
Yeah, I do too. I'm gonna wait and see if they get back in.
Bill has terrible service.
Watch to see. So looks like they've been kicked out of the session. So we'll give them just a moment to see if I'm sure they're going to zoom back in just a moment. Mr. Munoz, you're back. Maybe we
Right.
must have lost connection there. Can you still see your attorney?
Yes, I can.
Excellent. Okay, let's go over this real quick, just because we broke up again. All right, so on the charge of possession of a controlled substance in penalty group 3 between 200 grams or 400 grams, a second-degree felony, the state is asking the court to consider the evidence, defer a finding of guilt. That means not convict you of the offense, place you on 2 years community supervision with the cost of restitution of $180. That's for testing the substance in this cause. Also, you would be responsible for court costs of $290, reimbursement fees of $585, and the state is agreeing to dismiss your possession of marijuana, 4 ounces to 5 pounds. They're going to ask the court to take that in consideration with your plea in this case. Mr. Munoz, is that your understanding of the plea agreement?
Yes, that's correct.
Okay. All right. Understanding all of those things then, Mr. Munoz, how do you plead to possession of a controlled substance in penalty group 3 greater than 200 grams, less than 400 grams?
Guilty.
Are you pleading guilty to this crime because you are in fact guilty of committing the crime?
Yes.
And Mr. Munoz, has anybody threatened you, forced you, or otherwise pressured you to plead guilty in court?
No, Your Honor.
All right. The court does accept the defendant's plea of guilt at this time. Mr. Alanemi, any objections to the stipulation of evidence supporting the plea?
No, Your Honor, thank you.
All right, that is, the stipulation of evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, Judge, thank you. Rest.
Okay, all right, court's going to review the evidence. All right, the court, having considered the evidence, finds that there is enough evidence to convict the defendant of the offense. However, the court will follow the plea agreement today. The court defers a finding of guilt, places Mr. Munoz on 2 years community supervision, orders him to pay restitution of $180, court cost of $290, reimbursement fees of $585, And the court dismisses under section 1245, cause number CR 16-603, which is the possession of marijuana less than 4 ounces, greater than 5 pounds. Before we, because we've already done the plea paperwork, and I see that Mr. Munoz has already been fingerprinted. What I do need to order you to do, Mr. Munoz, as soon as you are released, I need you to contact the Van Zandt County Probation Department, because at this point, they don't have any way to contact you. They don't have an address, they don't have a phone number, or any other way to contact you to get you set up on your paperwork and going. So either
Right.
Mr. Alanami, you, or Mr. Munoz, when you're released, we need to get that done so that we can get this process going, so that whenever he is processed out, we can get him set up on probation.
Sound good.
Okay.
Okay.
Do you know when you expect to be released from Collin County?
No, I still signed for deferred tomorrow and here in Collin County, and then from there I gotta talk to parole and see whenever they're gonna lift the hold.
Okay, so you still may be in custody on a blue warrant for a little while?
Yes.
Okay, Mr. Alanami, do you have Mr. Munoz's best contact information, address, phone number, stuff like that, that you could provide to the probation department via email?
I have his entire family's information, so whatever you need, I can give it to you.
Okay, and I'll tell you what, Ms. Burns, are you there in the jail court? Sorry, no, they're in the Van Zandt part. I'll tell you what, let me,
Your Honor, she is.
okay, where do you want me to have Mr. Alanami send that stuff, send all of his contact information? What?
He can send it to my email, K Burns.
Hang on, that's okay. You don't want to say that on YouTube.
Give me 1 second.
Let me, I'll send in a message to Mr. Alanami. Otherwise, you're gonna get all kinds of junk mail and stuff like that.
If you want, Pat can email it to me. She was directly emailing me back and forth.
Who was?
Patty?
Patty? Okay. I'll tell you what, then,
Yes.
yeah, if you'll just send it to Miss Abraham, then we'll forward it to probation for you. Since you already have that email, okay?
Okay.
All right, thank you,
Yeah.
Mr. Amy, I appreciate it. All right, and to the Collin County Jail staff, if they can't hear me, Mr. Munoz, tell them I appreciate them making this happen, getting the setup for Zoom, okay?
Likewise. Thank you so much.
You're welcome. Have a good day, sir.
Likewise.
Thank you, Chris. Thank you, Judge.
You're welcome. Have a good day, sir.
Thank you.
You too. Bye.
We ready back in the Van Zandt County Jail Court?
Your Honor, it'll be just a minute.
Okay, sounds good. Hey, Miss Abraham,
Yes, sir.
you know, I just signed and filled out all of these, paperwork, all this plea paper for Mr. Munoz. And I've already forgotten how to do it since we moved to digital pleas.
I know.
Just showed you fall out of training pretty quick. So, all right, court will stand in recess for a few minutes.
Your Honor, we're ready to start back with Mr. Schmidt on the plea on Mr. Hegel.
All right, Mr. Hegel, give me just a second. Let me pull up your paperwork here. All right, Mr. Hegel, this is cause number CR 24-232, State of Texas versus Michael Hegel. Mr. Hegel, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. All right, Mr. Hegel, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Mr. Schmidt, as your attorney, are you pleased with Mr. Schmidt and the work that he's done?
Yes, sir, I am.
Do you have any questions for him regarding this case or the paperwork or anything else that you signed?
No, sir.
All right, Mr. Schmidt, do you believe Mr. Hegel to be competent?
I do.
And you've explained to him his rights as they pertain to this case, and also the advantages and disadvantages of a deferred adjudication plea?
Yes, sir.
All right.
And Judge, before we proceed, well, never mind, I'm sorry. Yeah, we've explained to him his rights. He understands those already.
And let me ask, so Mr. Hegel, I remember not very long ago, you were in my court on a different case, is that correct?
It was like 6 years ago and I went to TDC for it. Yes, sir.
6 years ago? Okay. Nothing more recent than that?
No, sir.
Maybe I'm confusing you with someone else. You're not the one that threatened to take his life and had to be arrested outside the courthouse by Sheriff Hendricks, are you?
No, sir.
That's not you? Okay, good.
I hope not.
Good. Good. Well, I'm not either. I couldn't remember. You look like him, and the name seems very familiar. And I wanted to make sure when I was asking the question about mental health, because I was like, okay, well, good. I made a mistake, and it's good for that mistake to be on my end and not your end. Okay, good. All right. So, Mr. Hegel, you are charged by indictment with a second-degree felony offense of robbery that does carry a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice. That is prison. I see here that there was an enhancement alleged by the state in the indictment, and that enhancement would elevate your range of punishment to that second-degree felony. Is that correct? Well, that's what it says on the paperwork. It says second-degree felony, and it says pled true, found true.
I believe that the intention was for the second-degree felony to be enhanced to a first by that enhancement paragraph.
Was your
Under the terms of the plea agreement. I believe that was Mr. Hartwell's intent.
what's the intent of the plea? Is the intent of the plea for it to be robbery second degree or robbery first degree?
Robbery first degree, Your Honor.
Okay.
And the reason the paperwork reflects second degree, the TDC sent a instructions that they want the charge to reflect what the base charge is, and then they would enhance it at TDC if that were the case.
And theoretically, Judge, I've admonished Mr. Hegel on a deferred that should he violate, he would be facing a range of punishment for a first-degree felony.
I guess my question then becomes on the plea true, found true. That would change the degree of the offense to a first degree. If and if Mr. Hegel were to be revoked and sentenced, then obviously there's gonna be another judgment. There's gonna be an interceding judgment. It would be a judgment adjudicating guilt. And on there, it would have to say the correct range of punishment. But my concern is here is that we're saying it's a second degree felony, but then the court's making a finding that it's true. I'm not sure that the court can make a finding that it's true on a deferred, can it? Does that, let's go off the record for just a second. Y'all refresh my memory on this. It's not a deadly weapon. Okay, it's not a deadly weapon, so there's no issue there.
Well, the enhancement's not a jurisdictional element. It's simply a punishment element. I would suspect that because it is a punishment element that, when I looked at the judgment, I would have expected it to reflect a first degree felony as well under the circumstances. So from that perspective, it would still be it wouldn't be an aggravated offense, but it would be, in other words, the punishment range is obviously different. I'm not aware of the memo from TDC. I understand the premise, but at the same time, I mean, on a deferred, we can do that. It's the deadly weapon finding that generally speaking, we can't deal with. And since it's not a sexual offense, those rules don't apply either. So I don't think it's an issue. I just think that for clarity's sake, the exposure needs to be clear. Because obviously if he is ultimately revoked, which we don't expect to happen, but if it were to happen, there may be some confusion down the road.
So Mr. Harwell, you're indicating that TDC wants the court to say it's a second degree felony, plead true, found true, and then if he's adjudicated, it would still say second degree felony, plead true, found true, and then on the face of the judgment, they would just then apply the law for a second degree enhanced with a prior. Is that what you're saying?
Your Honor, that's the way the memo was explained. And I do have a copy of it. I can read through it to double check. Your Honor, that is the way that I read the memo as well.
Would you mind would you mind just taking a picture of that and texting it to me?
Yes, sir.
And then if you want to put me and Mr. Schmidt together in a text group.
Made it 4 a.m. to 4 p.m. But I can change from the change the night shift to the morning shift. So either 4 p.m. to 4 a.m.
Are you planning on doing that?
Whatever works for probation. If it's better for me to switch to night shift, I can switch to night shift.
I would agree with Mr. Hartwell's rating based on mine.
Talking about the night shift.
Gotcha. Okay, thank you, Mr. Hartwell. Yeah, that does help clarify. Okay. All right, we're back on the record. CR 24-232 State versus Michael Tanner Hegel. All right, so Mr. Hegel, you are charged by indictment with a second-degree felony offense of robbery that does normally carry a range of punishment of not less than 2 years, up to 10 years. I'm sorry, up to 20 years in prison and a fine not to exceed $10,000. I see that there's an enhancement paragraph, which, if the court found that to be true, would increase the range of punishment to not less than 5 years or more than 99 years or life confinement in the Texas Department of Criminal Justice. I see that there's a plea agreement in this case. Upon you pleading guilty to robbery, the DA's office is recommending to the court that the court consider the evidence, that the court not convict you, but you should be placed on community supervision for a period of 8 years, including a $1,500 fine, court costs of $290, and reimbursement fees of $520. Mr. Hegel, is that your understanding of the plea agreement as well?
Yes, sir, it is.
All right. All right, understanding the range of punishment and understanding the charge in the plea agreement, Mr. Hegel, how do you plead to the second-degree felony offense of robbery?
Guilty.
And Mr. Hegel, how do you plead to the first enhancement paragraph? Is that true or not true?
True.
All right, and Mr. Hegel, are you pleading guilty to the primary offense because you are guilty of committing that offense?
Yes, sir, I am.
And Mr. Hegel, are you pleading true to the enhancement paragraph because the enhancement paragraph is in fact true?
Yes, sir, I am.
And Mr. Hegel, has anybody threatened you, forced you, or pressured you to plead guilty or true to the crime or the enhancements here in court?
No, sir, they have not.
All right, the court will accept the defendant's pleas of guilty and plea of true. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
All right, stipulation of evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that the state is in compliance. Victim impact statement was sent out in October, was not returned. State has been unsuccessful with follow-up attempts.
Thank you, Mr. Hartwell. Anything further from you?
No, sir.
All right, court will review the evidence. All right, the court, having considered the evidence, finds enough evidence to convict the defendant of this offense. The court will follow the recommendation of the DA's office. Court hereby defers the finding of guilt, places Mr. Hegel on deferred community supervision for a period of 8 years. In addition, the court orders him to pay a $1,500 fine, $290 court costs, and $520 in reimbursement fees. Mr. Hartwell, I'm assuming since you could not establish victim contact, there was no restitution. You were not able to determine if restitution was owed due to Mr. Hegel taking the victim's wallet.
That's correct, Your Honor.
All right, Mr. Hegel, you are hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence.
Thank you, sir.
You are. And Mr. Hartwell, would you do me a favor?
Yes, sir.
Would you mind sending me just scanning and emailing me a copy of your memo? Because I think that would be helpful to the court.
Yes, sir.
And I will study up on that and make sure that I'm doing it correctly.
I think that's all I have. I think that's it.
I'll be the judge of that, Mr. Schmidt. You hold on.
Yes, sir.
I'll be the judge of that.
Thank you for that.
By saying I'll be the judge of that, I'll ask Ms. Taberham. Ms. Taberham, is Mr. Schmidt done today?
I believe so, Your Honor.
All right,
I believe so. Okay.
thank
So
you.
she's the judge of it. You're free to go.
Thank you. Y'all have a good day. Welcome.
Okay, we have Mr. Guidry ready on Ladaria Ward. I think we have set for a bond reduction.
All right. Right, this is cause number CR 21-397, State of Texas versus Ladari DeAnthony Ward. This is a hearing on the defendant's motion for a bond reduction. I believe that Mr. Ward is being held on a motion to revoke. Is that correct, Mr. Guidry?
Yes, Your Honor.
All right, do you want to offer any testimony through your client today?
Just briefly.
All right, Mr. Ward, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. During your testimony, Mr. Ward, just make sure you speak up loudly and clearly so I can hear what you have to say, and so my court reporter can type down in her transcript what you're saying, okay? Go ahead, Mr.
Mr. Hartwell, you understand why we're here today, is that correct? Is that correct?
Yes, sir.
And part of the issue of your bond is that you missed a court date back, I believe, on December 3rd of 2024.
Yes, sir.
And prior to that court date being missed, where were you during the previous prior to that?
I was incarcerated in TDC.
Okay. And when did you get out?
August 11th, 2024.
And prior, when you got out, August 11, 2024, you had a previous attorney, is that correct?
Yes, sir. Mr. Richard Smith.
Okay, so, and at that time, you and Mr. Smith had spoken before and he would keep you updated on your court dates?
Yes, sir.
All right, and did you have, was there a breakdown of communication between you and your previous attorney as far as the December 3rd court date?
Yes, sir. He didn't contact me, but this court date while I was incarcerated, he sent email, and I mean, not an email, but a letter to my family that they got, but the one previous, we never got anything. He didn't tell me anything about it. I wasn't notified of it.
Well, let's kind of unpack that just a little bit. The letter that you're speaking about, did that make any mention of December 3rd? Are you referring to that court date?
No, sir. This court date right here.
Okay. All right, but going back to December 3rd, I want to make sure that you explain to the judge that, hold on, let me ask a question first. I want to explain to the judge, make sure that, did you have any knowledge of the December 3rd court date, 2024?
No, sir, none at all.
Okay, all right. So from that point on, you got out of TDC, you said in August of 2024, is that correct?
Yes, sir.
And didn't hear anything. And when did you learn anything about you missing court as it pertains to this case?
The day when I was pulled over, they told me that I missed court. I had a warrant for contempt of court.
All right, so warrant for court for failing to appear, is that correct?
Yes, sir.
And
Failing to appear.
okay, and when did you learn that? What day is that?
March 8th, 2025.
For this year?
Yes, sir.
And from that point, you were here, you placed here. Is it your understanding? And let me make sure that we're all on the same page. Right now, your bond currently stands at 100,000. Is that correct?
Yes, sir.
And you asking this court that, you're actually trying to resolve the case, but in the meantime, you like to bond out and make sure that if you do bond out, you'll make all your court appearances. Is that correct?
Yes, sir.
And you do understand what you're charged with. Is that correct?
Yes, sir.
And what are you charged with?
Possession of marijuana, 4 ounces less than 5 pounds, over 4 ounces less than 5 pounds.
And is your testimony today to the judge is that have you had any other issues as far as appearing in court, coming to court, or taking care of your business as far as that's concerned prior to December 3rd, 2024?
No, sir.
And if you are able to bond out, if the judge grants you a reasonable bond out, or if he lowers that $100,000 bond, will you be able to make all of your court appearances and adhere to the judge's rules and regulations while you're still trying to get this case resolved?
Yes, sir.
I'll pass the witness, Your Honor.
Chartwell?
Thank you, Your Honor. Mr. Ward, you were on bond with Brigham Home Bonds. Is that correct at the time that you were supposed to show up?
Yes, sir.
And were you not in contact with them for them to tell you your court date?
No, I contacted Mr. Richard Smith.
Okay.
He was the only one I was in contact with because I forgot the name of the bonding company.
Your Honor, no further questions.
Rest, Your Honor.
Go ahead. Any further questions? Mr. Guidry?
No, we'll rest, Your Honor.
Okay. I'm looking back here. It looks like Mr. Ward did post bond with the Brigham Home. And when he posted bond, he listed his address as 1800 North Hall Street, apartment 380 in Dallas, Texas, 75204. And it appears that was around March 22nd of 2024. And so after that, it appears that notice was sent by the court. The court coordinator, criminal court coordinator, sent notice of the hearing to that address. Are you saying, Mr. Ward, that that's not your address?
Yes, that's my address. But it was just
Were you in custody on December 3rd of 2024?
no, sir.
So we mailed a letter to your house.
I didn't get a letter to my apartment. I had no notice whatsoever.
Well, you did have notice because we sent notice to your house. Notice of court. I'm gonna show you right here. Let's make sure it's right. Is this your address?
Yes.
This is the date you're supposed to be, December 3rd, 24 at 9 a.m. for motion to revoke. We sent that to your attorney, Mr. Schmidt. We sent it to your bondsman, not only by mail, but also by email. And then here's the letter, the envelope that we sent. There's your address. You're saying that you didn't receive that notice.
No, sir. When was it sent out?
Date right here, October 25th, 2024.
No, sir, I never received it.
Okay, anything further, Mr. Guidry?
No, Your Honor. Nothing further, Your Honor.
Anything further, Mr. Hartwell?
Nothing further, Your Honor. Thank you.
All right, Mr. Guidry, any closing arguments or requests?
Yes, Your Honor. I believe, given Mr. Ward's track record, as far as this case is concerned, he desperately wants to take care and resolve the case. So we're ready to handle that. We're just kind of waiting on some other things to come through. In the meantime, Your Honor, given Mr. Ward's situation, I don't know if anything slipped through the cracks. Mr. Ward see himself that the court did send out a correspondence to him mailed to his apartment. I don't know if he got it or not. I don't know, Judge, I don't know. But we asked the court to consider a reasonable bond, and really expecting to resolve this case literally in a matter of weeks, hopefully, once we get everything, once we get on the same page with everyone else. But we ask that the court just respectfully reduce the bond to a reasonable amount so that Mr. Ward can make bond. And I think that he's trying to get a lot of his affairs in order as far as getting back to work, getting all of his legal issues behind him. And I think that he's going to be on the path to do so. But just trying to hit the go button, Your Honor. We ask that you take that into consideration.
Mr. Guidry, what is a reasonable amount? You didn't elicit any testimony about his financial abilities or talking with bondsmen or anything of that nature. What is it that you're asking? I mean, you can say reasonable, but what's reasonable to me may not be reasonable to you, may not be reasonable for your client.
Well, I hope, you know, I've seen in the past between 25 and 50,000, Your Honor. And I do understand that Mr. Ward did miss his court date. And so we're not going to point fingers. There was some miscommunications there, but at the same time, I know that in the past he did post a bond at 50,000. And I believe that a bond, given the fact that he's just recently got out of TDC, not really working yet, when I think of a reasonable bond, something in between 25 and 50,000, judge, to take into consideration, given his employment status at this point in time right now, and get on his feet and we can get this case closed out.
Was Mr. Ward working prior to him being taken into custody?
I was working before December. I had to start classes with my parole. It started in December. I was about to finish those classes, but I was arrested. Now I had to start those classes back over.
Are you going to be staying at the same address?
I would be staying in Red Oak with my family.
Okay, so a different address than that 1800 Hall.
Yes, sir.
Okay, and so you do have a place to live.
Yes, sir.
But you do not have a job currently, waiting on you when you get out.
I do have one waiting on me when I get out, but yeah.
Do you have any money saved? Do you have any money saved up, or assets, or cars, or anything of that nature?
My family was gonna put up the money. Was gonna help put up the money.
Okay. All right. Thank you, Mr. Hartwell. Anything?
Your Honor, under the circumstances, the concerning thing is that Mr. Ward wasn't communicating with his bondsman previously. However, I think he does understand the gravity of the situation. If the court were to grant a $50,000 bond again, I would state wouldn't be opposed to that. State would, however, ask that this case be reset on a shorter timeline than normal. I see that our next contested is April 29th. As this is an MTR, that'd be kind of a natural setting for it. We haven't had a chance to speak with Mr. Guidry before today, so I think there is a chance that we can get it worked out either way. But really, Your Honor, biggest thing that I would ask is that we get it set fairly quickly so that we can try and work through the case.
Okay. All right, then, Mr. Guidry, I will take all that under advisement, and I will issue a written order, and I will have my coordinator email that to your office, and I'll do that once we conclude today.
Yes, Your Honor. Thank you.
All right, so let's go ahead and set Mr. Ward. Let's set him on April 29th. That's so, Mr. Guidry, just so you're aware, the court, I set aside usually 1 day a month for contested hearings. And
Yes,
so
sir.
it doesn't mean that we have to have a contested hearing that day. It just means that that's the day I designate to take up things that are a little longer in time. So that would be April 29th at 1:30. That's where I like to set Mr. Ward's motion to remove.
Okay.
All right, so be in contact with the state, make sure that Mr. Guidry gets all of the appropriate discovery and those things, and y'all see if we all start working out the case. In the meantime, I will lower the bond. I'm going to go review the PSRS system that I'm required to review, and then I'll make a ruling on that, and I'll send you everyone notice.
Thank you, sir.
Your Honor, I did receive emails from Mr. Hartwell, and I did receive a copy of the state's motion to revoke. So I do have at least that much as far as Mr. I think Mr. Hartwell, maybe I'll send an email for some discovery if there's anything else out there.
Okay, very well.
All right.
All right, we'll see y'all back on the 29th.
Thank you, Your Honor.
You're welcome, sir. Good to see you. Okay, Ram, do we have anyone else out at the jail that we need to deal with?
No, sir.
All right, then that will conclude this afternoon's docket. Thank you, Mr. Hartwell. Do appreciate you.
Yes, sir. Thank you.
All right, y'all have a good afternoon.